You are on mute, Your Honor.
Good afternoon, Attorney Guyer. I do have your paperwork. I saw it. I'm just now trying to pull it up. Computer seems a little tired or whatever. Let me try to restart the program again. Attorney Flavio Hernandez. Do
Yes,
you
Your Honor.
have?
You have frozen.
I'm frozen?
You were.
Oh, okay. Okay.
You called my name and then it went silent.
Oh, that's probably because I was silencio. So the we are have you filed your motion for continuance, sir?
I drafted it and emailed it to the coordinator and asked her to forward it to the clerk.
Was it e-filed?
No,
sir?
Your
So-
Honor. No, I've had trouble with the e-filing system, Your Honor. I don't know if it's me or my computer. But generally I have more, I've tried several of the software options that they give you. And
Yes, sir.
I have not had success with that. I'm probably a dinosaur, Your Honor, and that's well, anyway, I did not e-file. I did forward it as an email to the prosecutor and the coordinator and asked her to forward it to the clerk.
Okay.
And you should have a copy if the coordinator gave you one, and I will need to mention an error in my motion.
Okay, not a problem. Counsel, if you will go ahead and call the court and see if they have it. And wait a minute, what is this? No, okay. All right, see if they can go ahead and bring it. Okay. All right. This attorney, I'm trying just to get everybody situated, at least recognized, and then but at the same time, I'm also trying to pull up your case, Attorney Guyer. So albeit multitasking, I am focused on making sure we get you taken care of. You've been so patient. Attorney LaHood, your case is
My client is Jamie Matakin.
okay. Sir, we're here for pretrial conference hearing today. If you're unfamiliar with the pretrial conference hearing, here I expect you to tell me how this matter is going to be disposed of by trial or by plea, and have the dates that would this disposition is going to take place. If you need to go ahead and call the consult with the court coordinator to get those dates for your intended disposition, then please do. Let's go ahead and put you in a breakout room, or do you need to confer with the ADAs first?
Can I confer with the state, Your Honor?
Not a problem. Let's go ahead and put Attorney LaHood in a breakout room. At ADA, Lynn Han, are you still conferring?
Yes, Your Honor, I am. Thank you.
Thank you much. Appreciate it. Ms. Quinn, is your head heavy? Okay, sit up. Attorney Alaman, I'm about to get on record. So do you have something quick, sir?
Yes, and I just wanted to tell you that I spoke to the prosecutor and got an offer on my client, the man who's in jail on a felony charge. I'm going to confer with him at about 4 o'clock at the jail and ask him what he wants to do about his case, but I got an offer, so
Oh, yes, sir. Counsel, you said you'll come back on the 21st.
the 21st.
Yes, you said you'll come back on the 21st and let us know how we're going to take care of the DWI.
All right. All right, well, I'll leave then. Come back on Thursday.
Right, sir. You wanted to talk to your client first and then probably consult with the felony ADAs or prosecutors and these
Yes.
prosecutors you talked to them.
I tried to
Okay.
talk to them, but they don't have the case yet. It just happened.
Oh, okay. All righty.
Thank you, Anna.
Okay, thank you. Have a great weekend, sir. Look
Thank
forward
you.
to seeing you Monday. Come. And counsel, Attorney Geyer, you're aware of the 1622 that's associated with your client, correct? You're muted, sir. You're aware of the 1622 associated with your client, and you'll be able to go ahead and address that when appropriate, sir?
Yes,
Thank you very much. State, do you have cause number 685-352 filled up?
Yes, Your Honor.
Let us get on record. Court is going to call cause number 685-352, State of Texas versus Matthew Carson Bain. Parties, please approach and identify who is before the court, starting with the state.
Victor Hernandez with the state.
Ronald Geyer for Mr. Bain, Your Honor.
And are you Matthew Carson Bain?
I am Matthew Carson Bain.
Are you the same that has been accused of driving while intoxicated, second offense, alleged to have occurred on the 20th day of May 2022 and is classified as a Class A misdemeanor? Are you the same so accused?
Yes, Your Honor.
Please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing else but the truth, under pains and penalties of perjury, so help you God?
I do.
Thank you. You may go ahead and lower your hand, sir. Since all the parties are on Zoom, the court is going to start sharing the court screen. Excuse me, Sarah. Mr. Bain, can you see the court screen?
Yes, Your Honor.
And counsel, can you see the court screen? Counsel, can you see the court screen?
I can see the
You may
screen,
be-
Your Honor.
Okay. I'm going to try to make it just a tinge bigger there, hopefully.
That's our recognition of Zoom conference, Your Honor.
Okay. State, can you see the court screen?
Yes, Your Honor.
State, on display is a document entitled State's Consent to Video Conferencing. Did you sign this document thus consenting to these proceedings by video conferencing?
Yes, Your Honor.
The state's video conferencing consent is made part of the record. Defense, on display is a document entitled Defendant's Consent to Video Conferencing. Did you, Mr. Bain, is this your signature here where I'm circling the cursor?
Yes, Your Honor.
Did you sign this document thus consenting to plea by video conferencing?
Yes, Your Honor.
Counsel, with your signature on the same document, do you join your client in consenting to these proceedings by video conferencing?
Yes, Your Honor.
The defendant's video conferencing consent is made part of the record. Counsel, how long have you been representing Mr. Bain?
I've represented him since the initiation of his arrest, and I represented him previously, Your Honor, in the prior DWI.
And if that sounds like it's at least more than 10 days. Counsel, are we applying for probation? And if so, what type?
It is deferred adjudication, Your Honor.
Mr. Bain, I draw your attention to the document on display. It's entitled Application for Deferred Adjudication Community Supervision. This is a 2-page document, this being the first page, and then this being the second page. Sir, I draw your attention to the middle of second page where I am circling the cursor. It states here that you personally appeared before me today, albeit you're appearing via Zoom. You are the defendant named in this case, and I have sworn you in. And under oath, you are stating that your application for deferred adjudication community supervision and the document entitled personnel data sheet, which was going to be attached as an exhibit to your application, is true and correct. Is that true and correct, sir?
Yes, Your Honor.
Both documents are true and correct.
Yes, Your Honor.
Keeping in mind that if your personal data sheet or documents are not completely filled in, they cannot be true and correct. Do you need to speak to your attorney before responding to this statement to understand the consequences of your response? And that is, the defendant understands and acknowledges that any untrue statement in the application or the exhibit, your personnel data sheet, may be grounds for denial or revocation of a community supervision in this case. Do you need to speak with your attorney?
I don't believe so, Your Honor.
And what is your response, sir? Do you understand?
Yes, Your Honor.
You understand the statement I read to you, and do you acknowledge it?
Yes, Your Honor.
I will sign the document, and your application is made part of the record. State, have you fulfilled your Brady and discovery requirement in this case?
Yes, Your Honor.
Counsel, defense, are you satisfied that the state has fulfilled its obligation to provide you discovery under Article 39.14 of the Texas Code of Criminal Procedure, as well as giving you full access to the state's files?
I have acknowledged that, Your Honor, and I agree.
State, is this matter subject to law enforcement disclosure? And if it is, has that been complied with?
Yes, Your Honor, and the state is compliant.
I will sign the discovery acknowledgement, making it part of the record. Thank you, State. State, do you have any motions for the court's consideration?
Yes, Your Honor, the state moves to waive and abandon the enhancement for the second offense and simply proceed on the first offense, PWI.
As a Class B?
Oh, yes, that's correct, Your Honor.
So this will be a DWI First Class B.
Yes, Your Honor.
Counsel, what say ye?
I have no objection, Your Honor. That was our agreement.
Without objection from the defense, that motion is granted. State, do you have any other motions for the court's consideration?
No, Your Honor.
Defense, do you have any motions for the court's consideration?
No, Your Honor.
Mr. Bain, I draw your attention to the documents on display. It's entitled "The Defendant's Waiver of Constitutional Rights and Course Admonitions." It's a two-page document. This is the first page, and now this is the second page, sir. Is this your signature where I am circling the cursor?
Yes, Your Honor.
Did you go over this document, two-page document, with your attorney?
No, I read it on my own.
And I answered all questions, Your Honor, concerning his rights to trial and giving up those rights.
And once you have completed the reading of this on your own and you having your attorney answer all your questions, did you freely and voluntarily sign this document?
Yes, Your Honor.
So with your signature here and your testimony, you're telling me that you understand everything in this two-page document as it was explained, reviewed and explained to you by your attorney.
Yes, Your Honor.
And you're satisfied with the representation of your attorney.
Yes, Your Honor.
He has done a job for you that is commensurate with the caliber of attorney experience and wise attorney that he is, he has been able to reduce this from a DWI second to a Class A misdemeanor to a Class B misdemeanor for you. The range of punishment, did he explain that to you?
Yes, Your Honor.
And did you understand it?
Yes, Your Honor.
And he explained to you your constitutional rights,
Yes, Your Honor.
and you understood those.
Yes, Your Honor.
With that understanding, Mr. Bain, do you freely and voluntarily give up your constitutional rights?
Yes, Your Honor.
Are you a US citizen?
Yes, Your Honor.
I will approve your jury waiver. I am going to sign it, make it part of the record. You will no longer be able to have a jury trial in this case. Counsel, with the information, were you able to apprise this defendant of his of the nature of the offense and the charges against him?
Yes, I was, Your Honor, and I believe
And
he
you feel,
understood.
thank you, counsel, and you feel your client is competent to enter into a plea today?
I have no question of his competency, Your Honor.
Counsel, do you and the defendant give up the formal reading of the information? Do you waive that?
We'll waive the reading of the information.
Say, what is your punishment recommendation in this case?
Your Honor, the state recommends 24 months of deferred adjudication, a $250 fine with court costs, 72 hours of community service, DWI intervention, U-Impact, TAIP, and all recommendations, and the ignition interlock for the full term.
Counsel, is that your understanding of the state's punishment recommendation to the court?
It is, Your Honor.
And Mr. Bain, is that your understanding of what your attorney has worked out with the state on your behalf in order to dispose of this matter for you today?
Yes, Your Honor.
With that understanding, Mr. Bain, how do you wish to plead? Guilty, not guilty, or no contest?
Guilty.
You're pleading guilty because you are guilty and for no other reason than the fact that you are guilty? Is that why you're pleading guilty, sir?
Yes, Your Honor.
I will accept your plea of guilty, finding that it is intelligently and freely made. However, I'm going to withhold my finding of competency and allow your attorney to go ahead and address any concerns regarding the 1622 report that is associated with Mr. Bain. Counsel?
Yes, Your Honor. I've reviewed Mr. Bain's interview with the people at the jail, and I believe he's completely competent. I have personally known Mr. Bain for some time. I know his parents, and I don't believe that there is any need for a mental health intervention in this case.
Thank you, counsel. I will find you that you are competent to enter into a plea today. Counsel, what, if anything else, on behalf of your client, and why should I consider this plea?
Your Honor, I believe that he is remorse in this, in his actions. He was fairly warned the first time. This is the subject of the plea negotiations. We waived a motion to suppress, and I believe that he's satisfied with the outcome and would ask the court to accept this plea.
Thank you, counsel. Very helpful. Mr. Bain, whom do you live with?
I live with myself, Your Honor.
I'm going to check something out here. Give me a minute. Mr. Bain, who is a Yesmi Mercado?
She's a friend.
And what's her, and does she live with you?
She does.
So you don't live by yourself then?
No, I thought you were asking if I live with my parents. I don't live with my parents.
I asked, whom do you live with?
I live with Esme.
Does she have a vehicle?
No, she does not.
Mr. Bain, do you have the ignition interlock on your vehicle at this time?
Yes, Your Honor.
Please describe for me by year, make, model of the vehicle and color of the vehicle that the ignition interlock is on.
It's a Toyota Tundra 2016 dark gray.
And when did you get that ignition interlock installed, sir?
It's been about 4 months.
And sir, what is the nature of your self-employment?
Construction and remodeling, residential.
And the vehicle that the ignition interlock is on, is that the vehicle that you use for your work?
Yes, Your Honor.
There are no vehicle, no other vehicles?
No, Your Honor.
So total, how many vehicles are in the household?
2.
And so you have another vehicle?
Yes.
You.
It's not mine, but there's another one here.
Oh, okay, and who's it, whose vehicle is that?
It's another friend. Her name is Brianna.
Okay, and does she live there?
Yes, Your Honor.
So now we have Brianna and Esme living with you.
Yes, Your Honor.
Okay, so when I asked you, whom do you live with? You first told me no one, then we had Esme, and now it's Brianna with a vehicle there.
Yes, Your Honor.
And that's Brianna whom?
I'm sorry,
What's Brianna's last name?
Patterson.
And sir, are those wages, do they represent weekly, bi-weekly, or every 2 weeks, bi-monthly, or monthly wages?
That's yearly, Your Honor.
Court is sharing the court screen. State, what was the BAC in this case?
Your Honor, that was 0.128.
State, what was it prior?
One moment, Your Honor, I think I might have to look into that. Oh, Your Honor, one moment, let me see here. Your Honor, it looks like that was on the 29th of August, 2019, and that was conviction out of County Court 11 here in Bear County.
That was a conviction?
Hold on, Your Honor, let me see if I have the details. I'm sorry, Your Honor, I might have misspoken there. I have to check and see if I have the actual outcome. Yes, Your Honor, from what I understand, it was probation with conviction.
So it's regular probation?
Yes, Your Honor, as I understand, unless the defense counsel has other information, yes.
Right, it was not deferred adjudication.
No, Your Honor, not from what I can see.
Okay. And when was that completed and how was it completed? Satisfactorily or?
One moment, Your Honor, let me look. Yes, Your Honor, it looks like on December 29th, 2020, the defendant satisfactorily completed that probation.
State, do you have any objections for this defendant to be referred to the Bear County Gives Back program?
No, Your Honor.
Are you, counsel, are you familiar with the Bear County Gives Back program?
I would like for my client to be aware of what that is, Your Honor.
Okay. It is an alternative method for that I have been providing for completing the first 40 hours of community service restitution. It's only good for 40 hours. The rest of the hours, there's other alternatives to be able to go ahead and satisfy that requirement. Let me see my, sure. Let me check on something real quick. Mhm. And so my CLO will go over, can go over the details of it and determine whether you are eligible. If you are eligible, if you're found to be eligible, it is up to you if you wish to participate in it. It's not mandatory from me. If you do not wish to participate in it, fine. If you do, you get 40 hours of community service restitution taken care of. But if you don't, you're still responsible for, either way, you're still responsible for 72 hours of community service restitution. I just give that to you as a way. So right after this, I'm going to place you in the breakout room with the CLO. Okay? So she'll go over the details of that and answer any questions that you have. And determine your eligibility.
Thank you, Judge.
Thank you, sir. Mr. Bain, I want you to think of this carefully. Are there any children in the abode that you live in?
No, Your Honor.
Counsel, is there any legal reason why this matter cannot be disposed of today?
No, Your Honor.
Mr. Bain, although there is sufficient evidence to find you guilty, in this case, I am going to withhold my finding of guilt, and I'm going to place you on 24 months of deferred adjudication community supervision probation for DWI first class B misdemeanor. You will be supervised and monitored by the Community Supervision and Corrections Department, otherwise known as probation, on behalf of this court with these following conditions: $250 fine plus court costs, 72 hours of community service restitution. I'm going to be referring you to the Bear County Gives Back program to satisfy 40 hours of it, of the community service restitution only if you are eligible and you wish to participate. DWI intervention, uimpact.com. TAP evaluation, and a moral recognition therapy class that must be completed.
Thank you.
Ignition interlock for the full term. And you have told me that that has already been installed for the 4 months. You must continue to maintain it for the full term of your probation. I will require 2 affidavits from you. 1, you will not drive any vehicle that's not equipped with an ignition interlock. And 2, from Brianna Patterson, whom you identified as a friend that lives with you and does own a vehicle, that she will not allow you to drive her vehicle under any circumstances. Otherwise, I will order an ignition interlock to be placed on that vehicle. Her vehicle must be identified by year, make, model, color, license plate number, and the last 6 digits of the vehicle identification number. I will need those 2 affidavits within 10 calendar days. I am going to have the community supervision officer prepare a 2-month status report to let me know how you're performing while on probation, and also conduct field visits. I will require you to have monthly UAs, randomized, and at this time, I will have the community supervision officer be able to monitor it versus putting you on UA call line, IVR. I'm also going to require that you participate in community sober support meetings 3 times a week, and one of those 3 times must be in person. And that will be for the term of your probation. The one that's in person, the CSO should provide you a log to go ahead and monitor it. The 2 that you may do online, if you wish, you can do all of them in person if you wish, but at least one must be once a week in person. You will, if you do it online, you must make sure that it is variable. So talk to your CSO or the CLO. They will be able to direct you to the ones that are verifiable, third-party verifiable to your CSO. It is your responsibility to make sure that that occurs. I am going to set your supervision fee at $50. Sir, what is the status of your driving license? Is it valid?
I believe it's suspended. Your
Okay.
Honor.
Including your affidavit that you will not be driving. You cannot drive on a suspended license. Okay. If you wish to go ahead and have vehicle operate, then you must have an occupational driver's license. Do you understand, sir?
Yes, Your Honor.
So I will expect a no driving affidavit within same 10 calendar days. Say, did I cover everything for you?
Yes, Your Honor.
Counsel, anything further on this matter?
No, Your Honor. Thank you very much.
Thank you. Mr. Bain, with regards to trial court certification of defendant's right to appeal, this has been a plea bargain case, and I am going to certify that you have no right to appeal. Now, sir, I'm going to need you to come down and provide us fingerprints and pick up a copy of this document. When would you be able to do that? Today is Thursday, so we got Friday, Monday, Tuesday, or Wednesday next week. Which one would you prefer to come down?
Monday, Your Honor.
Monday. And sir, you will be coming down to County Court at Law Number 2, located at 300 De La Rosa, San Antonio, Texas, 78205. We are on the first floor of the Cadena Reef Center. Now, you need to come down between the hours of 2 p.m. and before 4:30 p.m. Will you be able to go ahead and make that?
Yes, Your Honor.
Okay, very good. And please keep in mind that if we do not see you on Monday, the 21st of November, a warrant will be issued for your arrest. You understand that, right, sir?
Yes, Your Honor.
Mr. Bain, you have benefited from the wise counsel and experience and the high regard that your attorney is held in. Now, the way for you to thank your attorney for the hard work that he has done for you is for you to be successful on probation. More so, Mr. Bain, what I personally want for you is not only for you to be successful on probation, but successful in life. This is a second hit here. I'm sure that your attorney has explained to you the consequences. So I have provided tools here to be able to assist you. What I want you to be, Mr. Bain, is successful in life. I want you to be able to contribute significantly and effectively to this community that you enjoy and we also enjoy. Most importantly, Mr. Bain, is you understand the consequences. You seem like a very, very nice guy. Don't want to see you across from the bench again. I'm sure you do not want that for yourself. So please appreciate the work that your attorney has done for you and be successful on probation. Now, 24 months is a long time. Please communicate with your community supervision officer. If there is any issues that may come up that may impede your ability to be successful on probation. You've done it once before, and I'm fully confident that you'll be able to go ahead and be successful this time around. You can do it.
Thank you, Your Honor.
Thank you. Appreciate you going ahead and taking responsibility and being able to dispose of this case. I thank you for your time, counsel. I thank you for your time. And now I'm going to place you in a breakout room with the CLO that she can explain that Bexar County Gives Back program to you and determine your eligibility. We'll see you on Monday, Mr. Bain.
Thank you, Your Honor.
Thank you.
Your Honor, may I be excused? I'm going to make arrangements to speak with Mr. Bain when he comes out of the meeting with the CLO. Have him call
Okay.
me. All right. Thank
All
you.
right.
May I be excused?
Yes, sir.
Thank you, Judge.
Thank you. You moving? Okay, you got it. Okay. State, can you pull up cause number 676-387? Attorney LaHood, he'll probably be right back. State, are you ready to go ahead?
Your Honor.
Let us get on record.
That's the case, Your Honor.
You have, you ready? Okay. And State, have you received the defendant's motion for continuance?
One moment, Your Honor. I think I need to check with co-counsel here.
And no problem. You go ahead and do that. Let me give you a minute to go ahead and review it. It is quite substantial. Attorney LaHood,
Yes, Your Honor.
and your case, please.
My case is Jamie Matakin. I can get you a cause number. It is 684-223.
Yes. I have it, sir. And we're here for pretrial conference hearing, sir. How are we going to dispose of this matter?
The state submitted a motion to dismiss. They filed it through email or through e-filing.
Let me check that out, sir. Court is going to start sharing the court's screen. Ms. Mataquin, can you see the court screen?
It's very small, Your Honor.
Okay, let me see what I can do. That's about the best I can do. Can you see it now?
Yes.
It depends on the device that you're using. If you're not using your 72-inch TV screen, then it's going to stay small.
Okay.
Yeah, it's as big as your device. You good? Can you see it?
Yes, ma'am. Thank you.
Counsel, can you see the court screen?
I can, Your Honor.
Counsel, thank you so much for your time. Ms. Mataquin, your attorney has been able to secure a dismissal for you. I am going to go ahead and sign that. And it is done. And your case has been dismissed. Ms. Mataquin, you are free to go. Thank you so much for your time and patience today. I hope that you're satisfied with the results of what your attorney was able to go ahead and get done for you.
Yes, ma'am. Thank you, Your Honor.
Thank you so much. You have yourself a wonderful Thanksgiving, okay?
You as well.
All righty, thanks. Thank you, counsel. All righty, you're excused. Have a great weekend.
You as well. Thank you.
Thank you. State, oh, did that give you enough time to review the defendant's first motion for continuance?
Well, hold on, we got-
On clause number 676-387.
Yes, Your Honor.
Oh, AD Lin Han, you're ready to proceed on that matter?
Yes, Your Honor.
Okay. Court is going to call and get on record on cause number 676-387, State of Texas versus Griselda Rodriguez. Parties, please approach and identify who's before the court, starting with the state.
Ling Hong for the state.
Javier Hernandez for Ms. Rodriguez.
Ms. Rodriguez, would you please unmute? Are you Griselda Rodriguez?
Yes, Your Honor.
And you are also known as Griselda Sauceda?
Correct. I'm already divorced, so I'm back to Rodriguez. I've been divorced since 2020, I believe. So Sauceda is no longer, I should no longer have Sauceda.
Okay. You can consult your attorney, but you will understand that you are also have cases with the last name Sauceda, okay? You can talk to your attorney about that, but I wanted to make that as part of the record. And so, and your statements regarding that is also part of the record. So let the record reflect that the defendant is on this Zoom session with her attorney. State, are you ready to proceed? We are here for defendant's motion for continuance. At this morning, we had an announcement regarding a trial announcement called docket. At that, the state announced ready to proceed and the defense announced not ready. And the defense has filed a defendant's first motion for continuance. State, you have a copy of that
Yes, Your Honor.
and you're ready to proceed on this matter.
Yes, Your Honor.
Defense, you ready to proceed?
Yes, Your Honor, I am. As I mentioned, I did make an error I wish to correct.
Yes, sir. Please, it is your motion.
Yes, Your
Proceed.
Honor. On item number 1, it says additional blood testing. I would
Yes, sir.
change that to additional testing. I would like to remove the word blood. There's another use of the word blood in the second paragraph. And what I'm looking for, Your Honor, is an opportunity to,
If I may,
Yes.
Counsel, with that, and barring states subject to states objections, do I have your permission to make a pen and ink change on your motion, sir?
yes, please do, Your Honor.
Okay, I am striking the word blood in 2 instances of the first paragraph.
Thank you.
Yes, sir. I have initialed it. When you get an opportunity, if you're here, you'll initial the court's copy. And there is nothing to replace this word. I'm just striking it.
Correct.
Is that-
Yes, ma'am. That will leave.
Defense, thank you. Please continue.
Yes, ma'am. That will leave the options available for whatever testing may be available. I am not too versed on expert testing. I may wish to request a hair follicle sample testing. I think I've used that once before. There may be something else that I'm not currently aware of that is available, but I didn't want to say blood anymore.
Okay.
And the rest of the items stand.
Okay. State any comments with regard to the corrections that the defense has made to his motion?
The state doesn't have any objection to striking out the blood part.
Defense, please continue. It is your motion.
Well, Your Honor, my excuses are very feeble, and I will not stand before your cross-examination as I have been made aware of today. You are amazingly methodical, and you don't assume anything, and you take apart every little argument presented before you, and I have a great respect for you, Judge.
Thank you.
I think the issue, Your Honor, there's sort of an illusion taking place right here, right now, and in most every court hearing I've ever attended. And that is the illusion that there are two people on equal footing before the court, the defense lawyer and the prosecution lawyer. And that is as big an illusion as could possibly be imagined, Your Honor. I am by myself, Your Honor, absolutely by myself. There is absolutely no assistance to be had from any person on this whole earth. Nothing, Your Honor, not a bit of assistance. Everything has to be done by me. Every thought, every word, every email, every letter, every hearing, every journey to be taken, everything. It's a very large job under normal circumstances. And we are not in normal circumstances, Your Honor. Ever since 2019, when the courts were disrupted, there was a backlog of cases that just kept adding up, waiting for the opportunity for people to become Zoom familiar or to reopen the courts. On top of that, the public found out it wasn't happily married. And there was more domestic violence cases than San Antonio or probably the state of Texas has ever seen. And we, or myself, I'll only speak for myself as a court-appointed lawyer, I have never had so many cases thrusted upon me. They don't ask me, do you want this case? Do you want more cases? They don't ask me that. You're either on the wheel or you're off the wheel. And when you're on the wheel, they give you everything that they've got. And thanks to COVID, I think many capable attorneys have retired, leaving us with more cases than than I wanted. Your Honor, I have just been overloaded and have not been able to keep up with my cases. Consequently, Your Honor, I have removed myself from the felony wheel about 3 or 4 months ago. I no longer take any felony appointments. I was taking state jail, second degree, and third degree appointments. These constitute about half my caseload. The other half, under normal circumstances, were misdemeanors. However, because of the increase of the assault cases, my misdemeanors are more than my felonies. Again, 2 weeks ago, I removed myself from the Spanish-speaking appointments of the misdemeanors. I am taking the steps I felt appropriate and necessary to be able to have the number of cases that I can give the proper level of attention to. So now, without felonies and without Spanish cases, I may be able to correctly apply my assistance to the cases that remain. Unfortunately, there's still cases that are still assigned to me that I'm still trying to get off of my back, which I will not have in the future. I am attempting to solve this problem, Your Honor. So when I'm saying that there's an illusion in front of you, Your Honor, it's because there's a man standing in front of you representing the defense and a prosecutor representing the state, and they look like two equal people. And that is the furthest thing from the truth, Your Honor. The state has all the resources it needs. It's got what I do not have: secretaries, clerks, interns, investigators, experts, mentors. I don't know if the budget is limited, but I'm pretty sure it's bigger than mine. And therefore, Your Honor, we are not on an equal footing. So when I say I'm not ready or I need a continuance, Your Honor, I am coming from a completely different position than the state. The state can always say it's ready. As you pointed out to a defense lawyer this morning, there are other lawyers that can just step right up. They can lose a dozen lawyers and not miss a step. But that's not the case for me, Your Honor. I am the only one doing everything, and it's too much. It's too much, Your Honor. I'm doing what I can to relieve myself of as much of my burden. And Your Honor, honestly, I am not opposed to you removing me from this case at all. I've got more cases than I can handle. And if the court wishes to get a more capable, more available, younger, smarter lawyer, I am happy to step aside. There's no investment of my ego, and there's no greed or any financial interest on my part keeping me here. It's only that I'm doing my duty as I've been doing it for the past 22 years. So, Your Honor, my motion for continuance, that is the basis of why I have not been able to do everything that I need to do on this case. One would be to inquire about lab testing, possibly hair follicles. I don't know what else is out there. I don't know what we can afford, and I don't know what the court would pay for, but I would like to explore that. Skipping to number 3, the witness search, Your Honor. My client, by the way, Your Honor, my client is not saying she was not intoxicated. That is not an issue in our defense, not at all. Okay? The defense is that someone else was driving the car, someone else hit a parked car, tipped her car over, and ran out the window, leaving her the only person left in the car. There are 2 witnesses that have come forward to testify that someone else drove away with her in the passenger seat. These 2 witnesses were presented to the state, but were not convincing to the state. I believe if we have time, we can ask from these witnesses if they knew other people in that bar who saw them there, who may have seen the defendant there, who may have seen her being driven off in the passenger seat. Also, Your Honor, and again, I'm kind of going by TV standards, not the court appointment attorney standards, but there may be CCTV footage somewhere, either from that business or surrounding businesses. I don't know if they're going to be available. This event was 1 year ago. I don't know if they're going to be available, but it's something that would greatly change the position of the defense if there's a CCTV footage of someone else driving her car. And then back to number 2. Again, because of my overloaded caseload, Your Honor, I did not discover that my videos and audios discovery was inaccessible to me. I was able to download the e-discovery information, but it would not open. And I requested, after 2 or 3 emails, I was finally responded to that the audio and video recordings have been downloaded to a DVD, and they're at the office on the 4th floor. And I hope to pick them up tomorrow morning during my nuts and bolts seminar. These are my reasons, Your Honor. They sound feeble to me, but they do glimpse a reality that is never spoken of in the court, Your Honor. It's never spoken of. There's a lot more. I'm going to write a book about this disparity, Your Honor. It's incredible, considering that you're a presumed innocent, considering that it's her taxpayer money used without limit to convict her, but she gets me, who's not much, to defend her. Anyway, Your Honor, if we could get, I would say 60 to 90-day reset to allow for some of this investigation. I may be asking for an investigator. I don't like to spend the court's money or time. I rarely ask for anything outside of my own resources. But in this case, to try to find CCTV, to try to find possibly some home videos, if the accident happened in front of a person's home, I really don't know, Your Honor. I just know that it's more than I can do in this short time. And that's it.
Thank you, defense. State.
Judge, respectfully, the state is sympathetic to Mr. Hernandez's plight. The state would counter that, yes, we have more resources. We also have a lot more cases. Mr. Hernandez alerted me to an issue with his not being able to look at the discovery on November 10th, and it was promptly addressed. I believe it was made available for pickup by yesterday. The state has, in communications with Mr. Hernandez about this case and discovery issues, been as responsive as we can be, and generally are not opposed to his request for a continuance, but just would take some umbrage at his characterization that we are just sitting on vast amounts of resources to give to this one case that we've been trying to resolve, and are by no means trying to withhold any discovery or information, or not, take into account credible witnesses. Unfortunately, the state does not find them credible, and therefore we're at this impasse. The state has made numerous offers that it deems to be more than fair given the facts of the case and other factors. Reminder that this was set for a plea and defendant exercised her constitutional right to a jury trial. Not going to hold that against her, just this has been a case that's gone on and on forever. And again, the state is sympathetic to Mr. Hernandez's being short of time and resources. So is the state. And literally, it was a little over a week ago that the state was alerted to his inability to access videos for this case. So I'm not saying that Mr. Hernandez has vastly misrepresented it. Just, I guess, in short, the state is not opposed to his motion for continuance. For him to mount a suitable defense for his client.
Thank you, State. That is very helpful and gracefully stated. Defense?
Yes, Your Honor, I do believe we need sufficient time to do the research and investigation that I've described. This is a unique case, in my opinion, Your Honor. I've not had many cases like this. Again, she is not denying that she was intoxicated. That is a rare position for a DWI defendant. But her mitigating circumstance, Your Honor, is going to be difficult to prove that someone else was driving and ran away from the accident. That is an unusual case, Your Honor. I do need adequate time. I'm asking for 60 to 90 days.
Counsel, anything else?
No, Your Honor.
State anything further on this matter?
Judge, I have not been a prosecutor for long, but I will say in the short amount of time I have been here since the end of May, one would be alarmed by the amount of times that I come across cases where someone is driving someone else's car, crashes it, moves the person maybe into the driver's seat, or abandons the vehicle and runs away to let the person deal with the consequences of their actions. I'm just saying that I have seen it more than I thought I would. It is not new to me. It is rarely actually a defense.
You're saying it's actually a defense?
It's just really a story that I find to be credible, that there would be so many random people going and commandeering other people's vehicles and leaving them with a crashed vehicle intoxicated somewhere.
As I've mentioned, Your Honor, I have tendered 2 witnesses to the state stating that someone else drove away with my client in the passenger seat, and the prosecution does not believe them.
And as you can appreciate, if there's nothing further from either party, as you can go ahead and appreciate, that is the benefit and reason for a jury trial, and that the jury would be able to determine the credibility of those witnesses and be able to render a verdict based on their analysis. So defense, as you had mentioned, it is state funds that are available that provide the resources for the state, as well as the defense through a motion long ago and still withheld, has been able to be allowed to use state funds in situations where assistance is needed. Have you availed yourself to requesting for those?
Not
for that
yet.
assistance?
Not yet, Your Honor.
And the court does note that you have been appointed to this case since the 9th of June, 2022. And you have diligently appeared, responsibly appeared, and been here for your clients, sir. And I appreciate the eloquence of the arguments that you have made and your candor and forthrightness. I do have to disagree with you on on a couple of points, sir. You do, your attempt to sell yourself short is unacceptable to this court. You are very, very capable, and everybody did and is suffering from the consequences, or still recovering and from the consequences of COVID, and continue to struggle with it as we move forward. But we must move forward. This is a 2021 case. It is nearing 2 years old now. Would like to be able to get resolution for your clients. So if you could be able to avail yourself of those resources as quickly as possible, request those resources that are available to this citizen. It's part of her tax dollars that's going to be able to assist her. I need for that to be done right away. You said you're coming in here tomorrow for a CLE, an important CLE, sir, and you'll be able to go ahead and pick up the evidence that has been provided to you, the discovery that has been, again, provided to you by the state. It's waiting for you. And I expect those motions are requests for assistance. And sir, I will then, with that, I expect those to be filed, expect for you to be able to identify, if you can, the assistance that you need. And we're resetting this matter for trial on the 5th of December.
Yes, Your Honor.
Okay, Monday, the 5th of December, the trial. So understand, and again, as the state has expressed their sympathy, I am very sympathetic, and I understand everything that you have said, and that is why I'm taking this into consideration, because you have made some effort to and you realize, and you stated what that effort was in order to work towards preparation for this. You at a point had an understanding and presented to the court and the state that this matter may be resolved in another way, yet your client exercised the right, her constitutional rights. So let us proceed quickly to be able to dispense this and get it off her back as well.
Yes, Your Honor. Thank you.
Alrighty? Okay. You're extremely competent, experienced attorney, and she is lucky to have you representing her.
Thank you, Your Honor.
Thank you, sir. Appreciate it. We'll reset this and we'll see you on Monday, the 5th of December, ready for trial.
Yes, Your Honor.
Thank you.
Thank you.
The motion for continuance is denied, and you'll proceed and go forward.
Yes, Your Honor.
Thank you. Oh, actually, it's not denied. It's, okay. Denied in part.
Where you have
And Judge, I'm sorry to interrupt, but we have a mandatory office meeting at 3:30. Do we have anyone else that needs to be taken care of?
And at ADA Han, you are reading my mind. You must be seeing what I'm doing. I'm quickly reviewing the docket, and I think we are done. We're able to complete the docket.
All right,
And thank you.
wonderful.
Thank you so much. Appreciate everything that you guys do, and we'll see you tomorrow.
Thank you, Judge. See you tomorrow.
There you are. Thank
Thank you, ADA Hernandez. All right, well, thank you all. You all have a great evening.